Hello, and welcome to today's training session, presented by Julie Mosley and Emma Williamson of St Philip's Chambers. The purpose of today is to consider the current developments regarding domestic abuse and evidential issues in child sexual abuse cases in the context of family law proceedings, to include the Domestic Abuse Bill, the Integrated Domestic Abuse Court, and the position post JHVMF and re-HN and ASVTH. Without anything further, I'll pass you over to Julie and Emma. Thank you.
Hello. For the first part of our talk, we will be focusing on domestic abuse, and the second half will then be looking at the evidential issues in child sexual abuse cases. In respect of domestic abuse, there are a lot of new initiatives being announced, specifically starting from June 2020. That included the announcement of a launch of a pilot scheme for an integrated domestic abuse course. That's only part, of course, of the plan of reform of the court's approach to finding solutions in private law disputes, and builds on the recommendations within the recent reports, the President's Private Law Working Group in June 2019, the Time for Change paper in March 2020, and the Harm Panel report in June 2020. The Domestic Abuse Bill 2020, which is already amended by insertions in 2021, is also currently under consideration. And our focus today is looking at recent case law that has sent an increasingly clear message in respect of the need for hearings involving a fact-finding element to be properly set up in terms of a clear focus at the earliest stage on the need and remit of any fact-finding exercise, and consideration of what evidence is needed to achieve a fair hearing. That is frameworked within Practice Direction 12J. And secondly, and increasingly acute, is a focus on how the best evidence from both parties can be achieved, in particular in private law matters where the rising number of litigants in person leave the court with the onerous position of ensuring parity, not just between represented and unrepresented parties, but between alleged victims and alleged perpetrators. And again, there is clear reference in those authorities to the application of Family Procedure Rule 3A. When we were asked to do this training, the title in respect of the case law was limited to JH and MF. We are recording this on the 1st of April, and on the 30th of March 2021, the President handed down a judgment in re H&N and others, which is an umbrella consideration considering 4 appeals, and it is significant because it enabled the President to give some wider guidance. These notes were prepared with a wider background of review of case law, but in fact, because of those 2 significant cases, those will be the focus of this talk. And so I'll turn to Emma now to look at JH and MF.
JH and MF is a 2020 case and was a successful appeal following a fact-finding hearing in which no findings were made. Now, the notes that accompany this talk set out a summary of the factual background, but if we focus first of all on the principles arising out of the case.
So, looking at the principles, what does the appeal tell us about the need for procedural fairness in fact-finding hearings?
Well, procedural fairness is crucial when considering allegations of domestic abuse, in the same way as it's crucial in all cases. But additionally, where a party is vulnerable, thought needs to be given to the provisions of Part 3A of the rules. This appeal demonstrates how easily adopting an unusual procedure can give one party a significant advantage over the other. And so in this case, there were a number of procedural irregularities during the fact-finding hearing. First of all, the judge had directed that the appellant would give her evidence from counsel's row. She was doing so behind a screen, but not from the witness box. And that resulted in the judge being unable to hear some of what she said during her evidence. And it, of course, wasn't picked up by the tape either. The judge then directed that the respondent should give his evidence from the same position. Now, that appears to have been motivated by a desire to ensure fairness, with both witnesses giving evidence from the same location, but it in fact gave the respondents a distinct advantage in that he was then able to sit next to his Mackenzie friend, who then, for some inexplicable reason, assisted him whilst he was being cross-examined. The procedural difficulties continued during the submissions, with counsel for the appellant being curtailed due to time restraints, and the judge didn't call on the respondent at all, which of course then created an appearance of a partisan approach. The judge went on to make findings against the appellant in respect of matters which she hadn't been asked to comment on during her evidence and which didn't appear to form in any event part of the respondent's case. And then finally, due to the respondent being in person, the judge had intervened in the cross-examination of the appellant, which of course isn't in itself irregular. The danger was that the judge becomes an advocate and appears partisan, and that was very clear in the facts of this case. And of course, the appeal would have been allowed on the basis of procedural irregularity alone.
And what does this appeal tell us about the application of Family Procedure Rule 3A?
Well, Part 3A places the court under a duty to consider whether a party's participation in the proceedings or the quality of their evidence is likely to be diminished by reason of vulnerability, and if so, whether participation directions are required. So thought needs to be given to participation directions for any vulnerable witness or party, and the correct procedural approach is to consider the views of all parties, of the litigation friend if applicable, and of the witnesses giving evidence, and that's particularly important when the court is considering making directions of its own motion. Rule 3A.7 provides a list of matters that the court must consider when deciding whether there ought to be participation directions. So this includes the impact of any perceived or actual intimidation by a party, by a witness or by any family members, any disability, mental disorders, medical treatment that's taking place, the issues that arise in the case, and particularly whether they include abuse, the questions that will be asked of the witness and whether the issues in the case are contentious, the nature and the extent of the information already before the court, the characteristics and circumstances of the witness, and the costs of any measures which may be available. The measures which the court can then put in place include measures to prevent witnesses seeing other people in the room, the use of links, the tools and devices that are available to help with communication, including, of course, intermediaries. And as can be seen from JH and MF, the impact of failing to give proper thought to and proper application of Part 3A can lead to serious procedural irregularity. So these issues need to be considered, if possible, in advance of the day on which any evidence is going to be heard and in advance of any hearing.
And can you assist now with what this appeal tells us about the importance of keeping definitions of domestic abuse in mind during cases of this nature?
The appeal highlights the definitions contained within Practice Direction 12J and the importance of keeping these firmly in mind whenever parties raise issues of domestic abuse. On appeal, the court held that the judge had failed to keep in mind the definitions of domestic abuse, of coercive behaviour and of controlling behaviour, which of course are set out within the practice direction, and grave concerns were expressed in relation to the judge's approach to the question of consent. In relation, first of all, then to the definition of consent, the judge had accepted the appellant had asked the respondent to stop, and had also accepted that the respondent had failed to stop. He'd then gone on to observe that the appellant hadn't physically resisted and accepted that she was upset afterwards. And the judgment was flawed on the basis that it was the expression of a view that it's permissible and acceptable for penetration to continue after the complainant has said no, and that a complainant must and should physically resist in order to establish a lack of consent, which of course clearly it is not the appropriate definition of consent. And no thought appears to have been given by the judge at first instance to the fact that many victims don't resist whether that's out of fear or even out of embarrassment based on cultural, social or religious background or belief. And the judge had failed to explain the reasons for his finding that this was consensual intercourse, or at least the reason why, if it was evident to him that the appellant had become averse to sexual intercourse continuing, it wasn't also evident to the respondent, or why it was acceptable for the respondent to insist on sexual intercourse knowing that it was distressing and unwelcome to the appellant. And then in relation to coercive and controlling behaviour, the judge had predicated his conclusions on the assumption that the use of language can't form a significant part of the basis of a controlling relationship. And he also dismissed the throwing of objects as part of controlling or coercive behaviour without explaining why he'd done so. Had the court considered each of the appellant's allegations, they quite clearly could, taken together and if proven, have formed a pattern of controlling, abusive and coercive behaviour. The judge, though, hadn't made any findings about that, and he hadn't made any finding in respect of an incident of domestic abuse which he appeared to accept on the facts, where the respondent had pinned the appellant against a wall. And careful consideration needs to be given by any court undertaking a fact-finding hearing to the concepts, but also to the reality of domestic abuse, control and coercion, and the fact, of course, that it's not confined to physical violence.
What does this case tell us should be the court's approach to corroborative evidence, such as police evidence and text messages in a case like this?
This was a case in which the trial judge had before him police disclosure and, in fact, even a witness statement of a neighbour who corroborated the appellant's account. There was also evidence before the court of police intervention involving the respondent's previous partners. And so it's essential that the court hearing a fact-finding hearing not only considers the corroborative and contemporaneous evidence, but also carefully sets out any reasons as to the dismissal or lack of weight that's afforded to evidence of that nature. The judge also had before him a series of text messages sent between the parties, which were clearly relevant to the allegations by the appellant that she'd been subjected to abusive, coercive and controlling behaviour, and potentially to the allegations of sexual assault as well. Again, as with other forms of contemporaneous evidence, the court at a fact-finding hearing has to carefully consider the evidential value of such text messages in the context of the allegations that are made, and set out clearly the reasons for the weight that's attached to any such contemporaneous records. In JH and MF, the appeal court concluded that the judge wholly failed to understand that it's the effect on the recipient that is pertinent when considering whether any messages or communication is threatening and or abusive.
And what did Miss Justice Russell tell us should be the approach of weighing up oral evidence, particularly if one of the parties is vulnerable?
The appeal highlighted the fact that when considering the evidence of vulnerable parties, it's crucial to bear in mind their individual vulnerabilities and, of course, the experiences which, if their account is true, they've been through. And so the court's required to look beyond demeanour when reaching conclusions about the veracity of evidence, of oral evidence, and to give careful considered reasons for preferring the oral evidence of one witness over another. In JH and MF, the trial judge had made findings regarding the appellant's psychological state of mind without any expert evidence upon which to base such findings, and concluded that she was highly anxious, even commenting that she might be said to be of a neurotic disposition. Apparently, though, without giving any thought, first of all, to whether this might be the result of the past abuse by the respondent, but also to the role of the court procedure and the distress that is brought about to any witness by the fact of giving evidence and the impact that might have had on her ability to recall events.
What were the observations of the High Court as to the correct standard of proof in finding of fact hearings?
The standard of proof is the balance of probabilities, and the standard applies to serious sexual and physical abuse in the same way as it does to any other finding of fact. But what JH and MF tells us is that care needs to be applied to ensure that this is the standard that's being applied in fact, rather than just the standard that's being mentioned in passing. In JH and MF, the trial judge had been troubled by the binary nature of the law, in that, of course, if the fact is found to be proven on the balance of probabilities, then the proceedings continue on the basis that those findings are correct. And so although the judge referred himself to the correct standard, namely the balance of probabilities, he didn't in fact apply it because of the concern that he had about the way in which it would be applied moving forward. And so the trial judge had thus erred in law by applying or appearing to apply a higher standard of proof.
And what does this case tell us about the overlap between family and criminal spheres on allegations of serious domestic abuse?
Well, in 2018 in Riyadh, the Court of Appeal held that it's fundamentally wrong for the family court to be drawn into an analysis of what happened through the prism of criminal principles and concepts. And the focus must be, of course, on the best interests of the child. However, there are some concepts, for example, the approach of the Crown and Lucas, which are borrowed from the criminal law. And it remains necessary that there is congruence of approach in both jurisdictions and an understanding on the part of the family court of the relevant approach in the criminal law, particularly to issues such as consent. We clearly can't have a situation in which wholly different definitions and concepts are being applied in the two different jurisdictions simultaneously, potentially even to the same case.
What I will do now is give a summary of a case before we turn to HN, which was decided by Mr. Justice Hayden this year. It's F and M, and the reference is within the notes at page 16. It's a case in which the court was considering a children application and the effect of the behaviour of a father of children within one relationship, but actually the court considered the relationship behaviour described by two different women. It's a case which is difficult to do justice to the extent of the facts in any summary. It provides a clear example of coercive controlling behaviour, and findings of psychological, emotional and financial abuse were made. Both women, by the end of their relationships with this man, had lost their careers, they'd stopped communicating with family and friends, their social media accounts were closed, their cars were sold, they were isolated, they were, and to quote the judgment, coerced into a distorted relationship which gradually and relentlessly chipped away at their own sense of self and personal autonomy. The themes which emerge are ones that were developed by the President in the decision of H&M, and in specifically draw on the importance of the court recognising coercive and controlling behaviour, and also that coercive and controlling behaviour may be part of a longer term pattern of behaviour, and the impact of the pattern of behaviour is important for the court to consider. Some evidence or some events, when taken in isolation, don't have the relevance that they will take on unless it's considered in the wider evidential canvas. And therefore the overall approach to the assessment of evidence should be the same as in any case, but with the court factoring in the repetitive and continuous nature of patterns of behaviour. And in that context, there was consideration about the use of Scott schedules. The judge did not suggest he was giving prescriptive guidance, but the court observed that in cases where coercive and controlling behaviour is alleged, Scott schedules and a focus on specific incidents may be counterproductive because they obscure the serious nature of the harm within a pattern of behaviour, which sets us up now for Emma to consider Ray, HN and others.
Yeah, so HN and others is a very recent 2021 decision, and the citation is within the notes. The Court of Appeal considered 4 appeals which had taken place following fact-finding hearings in private law proceedings. In all 4, domestic abuse had been alleged. This was an appeal in which CAFCAS, Women's Aid Wales, Rape Crisis, Rights of Women, Families Need Fathers, and the Association of Lawyers for Children all intervened. And the judgment was delivered by the President. We've summarised the facts of the appeal within the notes. And again, we'll focus on the principles arising out of the case. But just to highlight that the case is significant because it sets out as a context the problems faced by the family court more generally, and references the private law initiatives currently in place to improve the ability of the court to deal with domestic abuse cases.
So in respect of this judgment, what does this judgment tell us about consideration of allegations of coercive and controlling behaviour?
The Court of Appeal approved the approach taken in F&M, noting that judgment is of value because it provides an illustration of what is meant by controlling and coercive behaviour, and sets out detailed facts as to examples of such behaviour. And it also highlights the statutory guidance on the topic published by the Home Office pursuant to the 2015 Serious Crime Act. Practice Direction 12J recognises that coercive and controlling behaviour can cause serious emotional and psychological harm, and a pattern of such behaviour can be as abusive or even more abusive than any particular factual incident set out within a Scotch schedule. The Court of Appeal observed that a child can be harmed by such behaviour in different ways, and examples include where the abusive behaviour is directed against or witnessed by a child, but also where it causes the victim of the abuse to be so frightened of provoking an outburst or a reaction that they're unable to give priority to the needs of their child. Or it may create an atmosphere of fear and anxiety in the home, which impacts on the welfare of the child. And it also risks, particularly with boys, setting up within the home values which involve treating women as being inferior to men. Of course, it's also important to keep in mind, and this is highlighted within the appeal, that not all directive, assertive, stubborn or selfish behaviour will necessarily be abuse. And of course, that can impact on the ability of professionals to recognise abuse of this nature.
So what should the approach of the court be in determining need for and scope of any fact-finding hearing?
The court must always have regard to Practice Direction 12J when domestic abuse is raised. And in relation to fact-finding hearings, paragraphs 5, 16 and 17 are crucial. The court must identify the factual and welfare issues involved at the earliest opportunity, often the FUDRA, and it must consider the nature of any allegation, admission or evidence of domestic abuse and the extent to which it's likely to be relevant to the making of child arrangements orders. The court must also determine as soon as possible whether a fact-finding hearing is required in relation to any disputed allegation of domestic abuse, whether that be to provide the factual basis for any welfare report, for the purposes of an accurate assessment of risk, whether it's necessary before it can move towards making welfare-based orders, or whether it's necessary before it considers the need for any domestic abuse-related activity. When determining whether a fact-finding hearing is necessary and proportionate in all the circumstances, the court must consider the views of CAFCAS. It must consider whether there are admissions or evidence which provide a sufficient factual basis on which to proceed, which of course may include any evidence that's been provided to the legal aid agency. And it must consider the nature of the evidence and the relevance of the allegations, if they're proved, to the issues before the court. But clearly the issues must be limited to those which are necessary to determine to dispose of the case. And at paragraph 37, the Court of Appeal gave some guidance about how to apply Practice Direction 12J, noting of course that the totality of the practice direction needs to be carefully considered. But in summary, the Court of Appeal said First of all, it's necessary to consider the nature of the allegations and the extent to which it's likely to be of relevance when deciding whether to make a child arrangements order, and if so, the terms of any such order. Second, in deciding whether to have a fact-finding hearing, the court should have in mind the purpose of the fact find, which of course is in broad terms to provide the basis of assessment of risk and the impact on the children of the alleged abuse. Thirdly, careful consideration has to be given as to whether it's necessary to have the fact-finding hearing, including what other evidence is available to provide of any factual basis and whether that's sufficient to proceed. And then finally, the court has to consider whether a separate fact-finding hearing is necessary and proportionate. The court and the parties should always have in mind that as part of its analysis, both the overriding objective and the President's guidance are set out in the road ahead. Now, it was of note within the appeal that CAFCAS observed that it's presently rare for there to be substantive CAFCAS involvement prior to the listing of a fact-finding hearing. Now, that of course renders it somewhat difficult for the court to factor in the views of CAFCAS as it's required to do by the practice direction. And certainly the Court of Appeal observed that this seemed to justify close consideration by those who were charged with reviewing the practice direction to consider how that might be given effect.
Was there further consideration or guidance given in respect of the use of Scott schedules in cases like this?
Well, there's been considerable concern for some time really about the utility of Scott schedules, and this was a concern that was recognised within the harm report as well as within F&M. The Court of Appeal observed that one striking feature of the dozen oral submissions heard during the appeals was that everyone was unanimous really that the value of Scott schedules in domestic abuse cases had declined to the extent that, in the view of some, they were now a potential barrier to fairness and good process rather than an aid. The first difficulty with Scott schedules is the need to focus on specific particularised factual incidents, which of course is somewhat difficult where the allegation is a pattern of coercive and controlling behaviour. And there's also pressure on litigants to limit the number of allegations to be tested by the court, often limiting the schedule to 6 allegations or so, which can produce a false portrayal of the relationship. And the Court of Appeal concluded that it sees the force of those criticisms and felt that serious thought now needs to be given to a different way of summarising and organising the matters to be tried at a fact-finding hearing, so that on the one hand, the respondent understands the case to be met, but also the process of organising and summarising doesn't so distort the focus of the court proceedings that the question of whether there's been a pattern is actually no longer before the court when clearly it should be. And that's an important point with which everyone involved in the appeal agreed. And one alternative proposed was to use a threshold type document, which would act as a formal pleading, but in a more narrative style than the Scott schedule. However, clearly the work on progressing recommendations and observations as to whether that is the way forward will be done by the private law working group and the harm panel's implementation group, which may of course in turn result in changes to the rules or to the issuing of fresh guidance in due course.
So in the meantime, how should the courts approach allegations of coercive and controlling behaviour?
Well, until changes are made, cases clearly must continue to be heard, but they must continue to be heard with an increased focus on controlling and coercive behaviour. And the Court of Appeal stated that consideration of whether the evidence establishes an abusive pattern is likely to be the primary question in many cases where there is an allegation of domestic abuse, irrespective really of whether there are other specific factual allegations to be determined. Clearly that may add to the length of fact-finding hearings in circumstances where the family court is already suffering underneath the sheer volume of work, and so proportionate timetables are going to need to be maintained. Where the issue is one of coercive and controlling behaviour, the need to determine specific factual allegations by reference to a Scott schedule may now cease to be necessary. And the Court of Appeal offered guidance about that at paragraph 59 of the judgment. It says where one or both parents assert that a pattern of coercive or controlling behaviour existed, and where fact-finding hearing is necessary, that assertion should be the primary issue for determination at the fact-finding hearing. And any other more specific factual allegations should be selected for trial because of their potential probative relevance to the alleged pattern of behaviour, and not otherwise, unless any particular factual allegation is so serious in and of itself that it justifies determination irrespective of any alleged pattern. A likely example, of course, there being an allegation of rape.
So going back to the question of criminal law concepts, what guidance was given in this authority about the relevance of those to in family considerations of this behaviour?
The Court of Appeal considered the earlier observations in RIAR 2018 and commented that there's a clear distinction on the one hand between judges needing to have a sound understanding of the potential psychological impact serious sexual assault may have on a victim's behaviour both during and after the event, and in the way that they may give their evidence. And then on the other hand, the importance of family judges avoiding being drawn into an analysis of factual evidence based on criminal law principles and concepts. So whilst it's not necessary to avoid using words such as rape as general labels or where they're used in ordinary speech, the focus mustn't be on whether behaviour falls into a particular definition, but rather upon what the parties have done to each other or to their children. Because of course the family judge doesn't make a finding as to whether a criminal offence has been committed, and any terms that are being used shouldn't give the impression to a parent listening that they've been convicted by a criminal court, unless of course there has been a separate criminal conviction. The Judicial College, following the judgment in JH and MF, and at the request of the President, has devised a freestanding sexual assault awareness training programme for judges, family judges, which will assist, of course, in dealing with this difficult area.
In respect of domestic abuse, this talk is to look also at the pilot scheme of integrated domestic abuse course and also the domestic abuse bill. I'm conscious that we need to do some proportionate timetabling of our own, given that this is only the first half of this talk. And of course, this talk is accompanied by much fuller notes. But speaking in respect of the pilot scheme, that is a response to the wider reform objectives, namely promotion of non-adversarial problem solving, effective management of cases through the course, and also putting children and families first. The focus of the integrated domestic abuse courts pilot is developing a one court, one judge approach and adopting an investigative, a problem-solving approach, as opposed to continuing with the adversarial model. Another objective is to seek to avoid not just inconsistency of judicial management of individual applications, but ideally to enable one judge to have oversight of all and any hearings in respect of the family, which currently may be scattered across family, civil, criminal jurisdictions. The judge will decide what evidence they seek to investigate, as opposed to considering the cases as presented by the two opposing parties. And there will be use of separate entrances, waiting rooms, and protective screens, just as we see in the domestic abuse bill, which is proposing that that becomes a presumption, an automatic way of doing things rather than as a result of application for special measures as we see at the moment. Just as the family drug and alcohol courts provide supports to the family with wider connections and support, IDACs again could assist perhaps with the idea of judicial monitoring of families and referral to services both in respect of victims, perpetrators, and child victim advocacy. The domestic abuse bill has already been amended in its passage through Parliament. Two key features that I'd draw to your attention would be the presumption of parental involvement is being considered. In other words, whether the right balance is being struck between the risk of harm to children and victims when considered with the right of the child to have a relationship with both parents. And secondly, how best to meet a commitment that's already been made to change the provisions in respect of orders barring abusers repeatedly making applications to take ex-partners back to court. And again, that is being considered. The other features of the bill are set out within the notes, but as I say, I am conscious of the time that we have, and so I suggest that we now turn to the second part of this talk, which is considering evidential issues in respect of allegations of child sexual abuse.
Yes, so the second part of our session is looking at the equally difficult and problematic area of evidence in cases involving children's allegations of sexual abuse. Whilst there are the clearest guidelines of what should be done by professionals investigating allegations of this type, in our experience, the court is still most likely to be being asked to reach a fact-finding decision in these serious and sensitive cases where there are flaws in the investigation or in the preparation of the evidence. So starting with AS and TH, which is a 2016 case, and citation is within the notes. Julie, what's the significance of the case, first of all?
Well, I would say the case is significant, not in fact because it creates any new interpretation of the law. What this case gives us is a focused overview of clear case law and guidance, which Mr. Justice MacDonald finds is still being ignored by professionals. And he reminds us of the damaging consequences for children involved in these cases. The facts of the case involve Mr. Justice MacDonald determining allegations made by a mother against father of one of her two children, namely that he'd physically and sexually abused both of the children and herself. The father was facing criminal charges in respect of the same allegations, with a trial date set later in the year. The court found that none of the allegations were proved, and at the conclusion of the hearing, the father then invited the court on the evidence to make a number of different findings, namely that each of the allegations made by the mother and the children were false, that the children had each been coached or influenced by the mother into making the allegations, that the mother had told lies to a series of professionals, that a number of professionals had acted in breach of their professional duty by failing properly to investigate the allegations, and that in consequence the children had suffered significant emotional harm, and the judge made each of those findings. The judgment starts with reference back to much older cases, Ray E in 1991 and the Leeds matter in 2008, in which the judges were already clearly expressing concern that despite the passage of time since the Cleveland report in 1987, witnesses had still not read it, or if they had, they'd ignored the conclusions. Mr. Justice MacDonald posed the question again whether the lessons of the Cleveland inquiry had been fully learned, and concluded that they had not. In particular, he notes, despite the fact that use of the term disclosure to describe a statement or allegation of abuse made by the child has been deprecated since the Cleveland report due to it precluding the notion that the abuse might not have occurred, every professional who gave evidence in this case, except the children's guardian, used the term disclosure to describe what the children had said to them. So the significance, therefore, of this case is it provides a clear restatement and reminder of how sexual abuse investigations should be conducted by professional agencies and police, the impact of failure to follow the guidance, and then how the court should assess the evidence in respect of allegations. And it draws together and sets out the clear guidance available for professionals in cases of investigating sexual abuse. There is case law, and I set that out within the notes. There is the Cleveland report, There are the ABE guidance, that's March 2011. There's guidance on joint investigative interviewing of child witnesses in Scotland. And then there's reference to 2 government papers. Again, the references are within the notes.
What does the case say about how sexual abuse investigations should be conducted by professional agencies?
Mr. Justice MacDonald sets out again the need for clear and scrupulous regard to the guidelines by all the different professionals involved with the family, and the effect of breaches, both on a court's approach to considering what weight the evidence can carry, but also that poor practice itself can lead to emotional harm to the child from professionals if the investigation is not open-minded, planned and thorough. And the stages he considers in this case are, firstly, initial contact with the child. In this case, clear ABE guidance wasn't followed. Secondly, proper recording in accordance with ABE guidance, which should include all professionals, not just police and social workers, and the need for recording not just what the child has said, but of the context of them saying that. And in respect of that, just to add more detail, the judge reflects on the need, because of child memory issues, for a high level of caution to be applied if the risk of obtaining unreliable evidence is to be minimised. Very great care must be taken by adults when speaking to children who've made allegations of sexual abuse, and when analysing and assessing the weight given to the statements of those children. Adults speaking to children who've made allegations of sexual abuse must always be careful to keep an open mind with respect to the allegations made, and to guard against the development of bias or preconceived ideas. The child should be listened to and taken seriously, whilst care is taken not to prejudge the issue. Adults speaking to a child who's alleging sexual abuse should not stop free recall of events. Adults speaking to a child alleging sexual abuse should not ask more questions that are necessary in the circumstances to take immediate action. And where it is necessary to ask questions, adults speaking to a child who's alleging sexual abuse should, as far as possible in the circumstance, ask only open-ended or specific closed questions rather than forced choice leading or multiple questions. Any initial questioning by adults speaking to a child should be intended to elicit a brief account of what's alleged. A more detailed account shouldn't be pursued, and that should be left to the ABE interview stage. And as soon as possible thereafter, the adult must make a comprehensive note of the conversation. And that record should detail timing, setting, people present, a full note of what the child said in the child's words rather than providing a summary, a full note of the actual questions asked, if any, and also what was said by anybody present. And the record should record the demeanour of the child and anything else that's felt to be relevant. And the adult should continue to record any comments made by the witness or events that might be relevant leading up to the legal process at the time of the ABE interview. In respect of the stages, the next stage considered by Mr. Justice McFarlane was the social work assessment. Initial action in securing the widest possible information about the child's circumstances and family background is an essential prerequisite to careful judgment and purposeful intervention. The principal aim is obtaining as comprehensive a picture of relationships and pattern of life as possible. An outline of the child's social development, together with information about the important relationships in the child's life, is vital information. Children and families should not be subject to multiple examinations and interviews simply because agencies and the staff have failed to plan their work together. And through the phase of initial assessment and preliminary decision making, social workers should be conscious of the fact that the presumption that abuse has taken place can have damaging repercussions for the child and the family. And equally, an abnormally low level of alertness to the possible of child sexual abuse may deter children from subsequently trusting adults sufficiently to reveal the fact of abuse to them. And he goes on then to consider the final stage, which is the need for police interviews to be planned and ABE compliant.
What does the case say about false allegations?
That care must be taken not to focus attention on statements by the child at the expense of other evidence, particularly where allegations of abuse are set in the context of private law disputes. The best practice guidance handbook, and the reference for that is provided within the note, cautions that, and I quote, an investigation which focuses attention on the statements of the child runs the risk of producing a false result if what the child says is unreliable, or if the child's primary caretaker is unreliable, particularly where the allegation emerges in bitterly contested Section 8 proceedings. Mr. Justice MacDonald quotes from Ray W., a 2014 matter decided by Lord Justice Ryder. Given the prevalence of false allegations made by parents against each other in private law proceedings, conduct at this level by a parent should be understood to be serious child abuse that will usually necessitate intervention by the court. Of course, it's also important to remind ourselves that the failures of professionals do not lead to an automatic consequence where the court finds positively that the mother has coached or manipulated the children into making false allegations. Rather, the judge describes that repeated and persistent poor practice by a range of professionals aided the mother to succeed in enclosing the narrative she had created in what he describes as a hermetically sealed bubble, therefore succeeding in preventing professionals carrying out the checks that would have revealed that the allegations that were being made first by the mother and then by the children required at the very least a critical and questioning appraisal. Indeed, by reason of their almost entirely unquestioning approach towards the mother, a number of professionals simply acquiesced to their confinement in that bubble. Had professionals adhered to well-established guidance and procedure, they would have discovered the allegations lacked credibility.
What does Mr. Justice MacDonald say about the court's approach to assessing sexual abuse allegations?
So the judge reminds us that the court should adopt a two-stage process. First, is there evidence of sexual abuse? If so, is there evidence of the identity of the perpetrator? The court should consider all the relevant evidence in the case. There was a broad canvas of available relevant evidence concerning the child's family background, relationships, pattern of family life, social development, involvement with other agencies prior to the making of the allegations. And the judge sets out the consequences of breaches in the approach to evidence. If a joint child abuse interview conducted by police and social services doesn't follow the memorandum of good practice, not only does that affect the forensic value of the interview, but it may impede or contaminate any further assessment of the child ordered by the court. And he goes on to find at paragraph 52, where there has been, in this case, a failure to follow interviewing guidelines, the court is not compelled to disregard, although the evidence obtained in interview, disregard altogether the evidence obtained in interview, but it may rely on it together with other independent material to form a conclusion. However, where the court finds no evidential weight can be attached to the interviews, the court may only come to a conclusion that relies on the content of those interviews, where it has comprehensively reviewed all of the other evidence.
And what was said about the consequences of the breaches on the children?
He said was, I'm further satisfied on the evidence that the actions of certain professionals in this case breached well-established principles of good practice, which actively contributed to the difficulties I've set out above and materially prejudiced the welfare of both of the children. In this case, he went on to find almost all professionals and agencies involved with the children proceeded on an unquestioning basis that mother was telling the truth and therefore failed to interrogate that by basic inquiries. A number of the professionals had failed in their duty to keep accurate records of what mother and the children were saying. A number of professionals questioned the children outside the setting of the ABE interviews. Agencies had failed to coordinate their interventions with the children. At the police interview stage, there'd been significant breaches in the children's interviews. And there'd also been extensive therapy and CAMHS intervention before the finding of fact hearing conducted on the basis that both children had been abused in the manner alleged by the mother. That's the basis of the therapy.
So leading on from that last point, what is the guidance that exists in relation to pretrial therapy in sexual abuse cases?
Achieving Best Evidence in Criminal Proceedings, March 2011, accepts that there are cases where separate pretrial therapy or counselling work will be necessary to meet the needs of the witness. There's also guidance in Provision of Therapy for Child Witnesses Prior to a Criminal Trial Practice Direction, that's 2001. What the guidance sets out is once the video recorded interview is complete, it should be possible for appropriate counselling and therapy to take place. It should become standard practice to inform the police and the CPS about the nature and the content of the therapy in each case, because the defence may justifiably wish to know about both the nature and the content of the therapy that's taken place before a child gives evidence in cross-examination. And it sets out then precautions which need careful consideration, and that guides the approach to be taken.
How does this guidance about therapy bear upon the family court?
Well, I suggest two most common situations. Firstly, if during court proceedings there is a view that a child is likely to be a witness in a family or criminal trial but is considered to need therapy, then the court needs to be aware and make sure everyone else is aware of the very clear guidance available before decisions are made, because of the risk that the therapy could contaminate the evidence by, for example, the process of repeated discussion, or that the evidence is compromised by that suggestion being open to people. Any decision should be made in communication with the police and CPS, and if therapy goes ahead, the therapist must be fully familiar with the guidance. But for example, self-esteem work can be done and properly recorded without need to discuss specific allegations. And secondly, if the court is dealing with fact-finding issues, there's a clear importance to establish what therapy, if any, there's been, when it was in relation to any allegation or in any interview, the content of the therapy, were the allegations talked about, was it on the basis of them as an established fact, and what recording there is of what was discussed. And my suggestion is it would be prudent for this information to be available, if possible, by the stage of any Ray W decisions within proceedings about children giving evidence.
What are the evidential implications of a failure to comply with best practice and the guidance for ABE interviews?
So the Court of Appeal has made it very clear that a failure to comply with guidance will not necessarily render the evidence obtained incapable of establishing facts of physical or sexual abuse. Starting point is Ray B, where the Court of Appeal says in a family case, evidence of this kind falls to be assessed, however unsatisfactory in its origin. So there's accordingly no question of the evidence being inadmissible, no matter how unsatisfactory the ABE process. The focus of the family court in cases where there have been failures to comply with the guidance will be on the value of the evidence and the weight to be attached to it rather than admissibility. And perhaps a parallel can be therefore drawn in the general approach to hearsay evidence in the family court. In some cases, of course, the failure to comply with guidance extends so far as, in fact, there may have been no ABE interview. That situation was considered by the President in a matter of Ray J 2014, where there was a vulnerable adult who made allegations against a child's father when she herself was 17. There hadn't been an ABE interview. That didn't rule out consideration of the other evidence about what the complainant had said, for example, of what she'd said to other professionals, and also the oral evidence to the court. But the court had to be careful to consider the impact of the lack of the ABE interview. The fact that the judge in that case hadn't expressly mentioned the absence of the interview or brought that absence into the evaluation was held to be a significant omission. And finally, in Ray E in 2016, the Court of Appeal held that the judge must engage in an analysis of the process used to gather the evidence and the allegations of the children, so as to establish whether, in the circumstances, it was reliable. It's important, therefore, when considering flawed ABE interviews that don't meet the guidance, to look at the external circumstances and the facts of the case.
So turning then to the 2019 judgment in Re P, Mr. Justice MacDonald refers us back to the guidance of AS and TH. What's said within that judgment about the effect on failures to prove a fact?
He reminds us that a failure to find a fact proved on the balance of probabilities does not equate without more to a finding that the allegation is false. Having heard, what he says is, having heard and considered the evidence, it's open to the court to conclude that the evidence leaves it unsure whether it is more probable than not that the event occurred, and accordingly, that the party who has the burden of proving the event occurred has failed to discharge that burden. The Supreme Court has made it clear that whilst not routine, this outcome is permissible in cases relating to children.
And what's said about hearsay?
I provide a quote within the notes, but I'll summarise the part that I've emphasised, which is Mr. Justice MacDonald saying, I remind myself, a court considering the hearsay evidence of a child must consider not only what the child has said, but also the circumstances in which it was said, and goes on to emphasise again the fact that it's long been recognised that care must be taken not to focus attention on statements made by a child at the expense of other evidence.
What does Re P tell us about memory, and what guidance is given about children's memory in particular?
There is a lengthy section considering the understanding now of memory and the development of memory. And I set out the following list that Mr. Justice MacDonald says that he is satisfied that the court can take judicial notice of. That children, especially young children, are suggestible. Memory is prone to error and easily influenced by the environment in which recall is invited. Memories can be confabulated from imagined experiences, and it's possible to induce false memories, and children can speak sincerely and emotionally about events that in fact did not occur. Allegations made by children may emerge in a piecemeal fashion, with children often not reporting events in a linear history, reporting them in a partial way and revisiting topics. The wider circumstance of the child's life may influence or explain or colour what the child is saying. Factors affecting what a child says something, when a child says something, will include their capacity to understand their world and their role within it, and requiring caution when interpreting children's responses to behaviour or parts of the body through the prism of adult learning or reading. Accounts given by children are susceptible to influence by leading or suggestive questions, repetition, pressure, threats, negative stereotyping, but also encouragement and reward and praise. And accounts given by children are also susceptible to influence as a result of bias or preconceived ideas on the part of the person talking to them. They are susceptible to contamination by statements of others, and that may influence a child's responses. They may embellish or overlay a general theme with apparent convincing detail that could be highly credible, and delay between an event recounted and the allegation being made may influence the accuracy of the account given. And within that context, what the judge stresses is the way and the stage at which a child is asked questions and interviewed will have a profound effect on the accuracy of the child's testimony. And he stressed again the dangers of professionals proceeding on the basis of the child must be believed, as opposed to the child must be listened to and taken seriously.
Finally then, what is said within REP in relation to how the court should evaluate any flaws that have taken place in following the guidelines?
Well, of course, the authorities all stress the need for professionals to be aware of the guidance and to be conscious and try to keep to that guidelines. But this authority also sets out the court doesn't expect perfection, and it would be unrealistic to do so. Complete adherence to guidelines doesn't mean an allegation is true. Wholesale failure to adhere to guidelines doesn't mean an allegation is false. Failures by professionals in investigations of allegations of abuse, and the fact that those failures must be taken into consideration when considering weight to be attached to the strands of evidence, does not of itself preclude the possibility that the allegations are true. And therefore, there has to be a careful examination of all evidence. And I've emphasised in the notes the quote, "There is no question of this evidence being inadmissible for failure to comply with the ABE guidelines." That's not been suggested as an argument for either parent. In a family case, evidence of this kind falls to be assessed, however unsatisfactory in its origin. To hold otherwise would be to invest the guidelines with the status of law of evidence, and it would invite the questions, what failures have the consequence of inadmissibility? Clearly, some failures to follow the guidelines will reduce, but by no means eliminate the value of the evidence. Others may reduce the value almost to vanishing point. The relevant question for the court is whether any omissions or errors are made are forensically significant. So I think that brings us to the end of our training, and we hope you found it useful. Thank you.